Trusts and wills. Understanding the differences and contextual significance. When it comes to estate planning, understanding the mechanisms available is crucial for effectively managing one's assets, ensuring the wishes of the deceased are honored and providing for loved ones. Two of the most commonly used legal instruments for this purpose are trusts and wills. Each serves a distinct purpose and has unique characteristics, advantages, and limitations. Definition of a will. A will is a legal document that outlines how a person wishes their assets to be distributed upon their death. It typically includes provisions for appointing guardians for minor children, designating beneficiaries who will receive specific assets, and naming an executor who is responsible for managing the estate and ensuring that the terms of the will are carried out. Definition of a trust. A trust, on the other hand, is a fiduciary arrangement where one party, known as the trustee, holds assets on behalf of another party, called the beneficiary. Trusts can be established during an individual's lifetime, inter vivos trusts, or can be created upon death through a testamentary trust. Creation process. The process of creating a will is relatively straightforward. A testator, the person creating the will, must be of sound mind and follow specific legal formalities, such as signing in front of witnesses. Trusts require more complex legal drafting and must comply with statutory regulations to ensure they are validly established. Timing of effectiveness. A fundamental difference between wills and trusts lies in their timing. A will takes effect only after the death of the testator and must go through probate, a court process that validates the will and oversees the distribution of assets. In contrast, a trust can become effective immediately upon creation, allowing for asset management even while the grantor, the person who establishes the trust, is still alive. Probate process. The probate process associated with wills can be lengthy, costly, and public. This means that details about the deceased's assets and beneficiaries may become public record, potentially leading to disputes among heirs. Conversely, assets held in a trust do not go through probate, allowing for quicker distribution to beneficiaries while maintaining privacy. Flexibility. Trusts often offer more flexibility than wills when it comes to asset management and distribution. For example, a trust can include specific instructions regarding how and when beneficiaries receive their inheritance, such as at certain ages or upon achieving specific milestones, while wills typically distribute assets in full at death. Control over assets. A trust provides greater control over how assets are managed during an individual's lifetime and after death. The grantor can set conditions on distributions or appoint trustees to manage the assets according to specific guidelines, whereas a will transfers ownership directly upon death without stipulations beyond that point. Tax implications. Trusts may provide significant tax advantages in certain scenarios, particularly with irrevocable trusts, which can help reduce estate taxes by removing assets from the grantor's taxable estate. Wills do not generally offer such tax benefits, but may still carry tax implications based on inheritance laws applicable in different jurisdictions. Asset protection. Some types of trusts provide asset protection against creditors or lawsuits, shielding assets from claims against beneficiaries' personal liabilities. Wills do not provide such protection as they typically lead to direct transfers of ownership. Management during incapacity. One critical aspect of trusts is their utility in managing assets if the grantor becomes incapacitated due to illness or injury. A successor trustee can step in to manage the trust's assets without needing court intervention, whereas a will does not address such situations. Types of wills. There are several types of wills, including simple wills, testamentary trusts, which come into effect upon death, living wills, which specify healthcare preferences, and holographic wills, handwritten. Each serves unique purposes but fundamentally operates under similar legal principles. Types of trusts. Trusts also come in various forms such as revocable trusts, which can be altered during the grantor's lifetime, irrevocable trusts, which cannot be changed once established, special needs trusts, to benefit individuals with disabilities without affecting government assistance, and charitable trusts, which benefit charities. Cost considerations. Generally speaking, establishing a trust is more expensive up front than creating a simple will due to legal fees involved in drafting comprehensive trust documents. However, avoiding probate costs later can make trusts financially beneficial overall. Public versus private. Wills become part of public records once probated, allowing anyone to access their contents post-death. This transparency may lead to family disputes or challenges to the validity of the will. Trusts maintain privacy, as they do not go through probate. Revocation and amendment. Wills can be revoked or amended relatively easily with subsequent documents or codicils. However, irrevocable trusts cannot be modified without consent from beneficiaries or through court intervention under certain circumstances. Court oversight. Wills typically require court oversight during probate. Judges validate wills and ensure adherence to state laws regarding distribution. Trusts operate outside of court supervision once established correctly, unless legal disputes arise necessitating court involvement. State-specific laws. Both wills and trusts are subject to state laws which dictate how they are created, executed, administered, and contested. Thus, local legal nuances can significantly affect their effectiveness. Disputes over validity. Challenges regarding the validity of a will can arise due to claims about undue influence or lack of testamentary capacity. These disputes usually unfold in court during probate proceedings, while trust disputes often stem from disagreements over fiduciary duties or mismanagement. Beneficiary designation. Flexibility. Trusts allow for more intricate arrangements concerning beneficiaries compared to wills, where distribution typically follows straightforward paths. Trusts may have multiple tiers of beneficiaries or contingent arrangements based on certain conditions being met. Contingency planning. In terms of contingency planning for various life scenarios, like divorce or remarriage, trusts provide superior mechanisms as they allow individuals to revise beneficiary designations proactively without lengthy legal processes involved in altering wills. Creditor claims handling. In scenarios involving creditor claims against an estate after death, assets held within a trust may be shielded from claims made by creditors against individuals, since these assets technically belong to the trust rather than directly being part of one's estate. Complex family dynamics. For families with complex dynamics, including blended families or those with special needs members, trusts can cater better by offering tailored arrangements that address individual family members' needs while ensuring fairness across diverse relationships. Conclusion on usage. In conclusion, both wills and trusts serve essential roles within estate planning strategies. However, choosing between them, or deciding to use both, requires careful consideration based on individual circumstances, including financial goals, family dynamics, tax implications, and personal preferences regarding asset management. Final recommendations. It is advisable for individuals contemplating estate planning options to consult with qualified legal professionals specializing in this field who can provide tailored advice based on unique situations while considering both current laws governing estates and anticipated future changes therein. Understanding these two instruments empowers individuals to make informed decisions about their estate planning needs while ensuring peace of mind, knowing their affairs are in order according to their wishes.